It's Friday, so it must be Friday Facebook Live with Tanya Friedman from Kinetics USA and our panel of esteemed lawyers. Welcome, Jacob. Welcome, Chris. We are waiting for Carl. He should be joining us shortly, but we wanted to get started right away. So thank you, everybody, for joining us. We are going to be talking about immigration questions today. Immigration has been in the news, and we also have had some exciting developments with the Visa Bulletin. So we can't wait to hear our esteemed panel's opinions about the Visa Bulletin, what's happening at the moment, and then we're also going to be getting to all of your questions. If you're watching today, please introduce yourselves and let us know what your name is and where you are watching from. And we will have everybody watching from all around the world, and we want to ask as many questions as possible of the panel. So before we start the questions, just a brief introduction. The reason why we started having these once a month Facebook Live sessions is because for many years now we've watched as many of you have struggled with immigration questions, and in the LaFora forum specifically have been asking each other questions, immigration questions. I'm not a lawyer, we're not lawyers, and I just felt that it was really important. I was an immigrant myself many years ago. I came to the US almost 20 years ago, so a proud American today. But I really felt it was important that you get answers from the experts. So this is the opportunity of a lifetime, because the immigration process is not an easy one, as we know. It can be it's very exciting, but it's also very stressful and challenging. So you want to make sure you're getting the right information. So if you're joining us, please introduce yourselves and let us know where you are calling in from. Jacob, I'm just looking here. We are live, right? Because there we go. Okay.
Yeah, we are.
Okay, perfect.
Carl,
okay.
Thank you.
Oh, good. So, hi, Carl.
Hi, good morning.
Carl is joining us from Texas this morning, right, Carl?
Yep, the Federal Bar Association in Austin, Texas.
Okay, wonderful. Okay, so a brief introduction of the panel. Louise from LaFora has put the bios of the lawyers into LaFora, so you have any questions about their background, and you can see that they are the real deal. These are the experts, so you can read up about their bio, but I'm going to give you a little bit of information about them before we get started on the questions. So I'll start with Carl. Attorney Carl Schusterman has over 40 years of experience practicing immigration law. He served as a trial attorney for the U.S. Immigration and Naturalization Service from 1976 until 1982, when he entered private practice. He has been designated as certified specialist in immigration and naturalization law by the California State Bar. For 10 years, he's been voted as one of the best lawyers in America, as a super lawyer by his colleagues at the bar. In 2018, he was featured in Super Lawyers magazine. He's been named one of the top 15 corporate immigration lawyers by the Human Resources Executive magazine, and he's been listed in the International Who's Who of Corporate Immigration Lawyers and the Chamber US Guide for Leading Business Lawyers. So read up more about Carl on the LaFora forum. And then we also have Chris Marcello, who is joining us now. Chris is the managing partner and moderator. He's a moderator of LaFora. So he's been an immigration attorney since graduating from University of Cincinnati College of Law in 1998. Specializes in healthcare. His client base is wide-ranging and includes the largest healthcare companies in the U.S. His written work has been featured in American Lawyers Association annual publication, the Cincinnati Bar Association report, worldwide PRC mobility, variety of online applications. He's a speaker at many conferences, and he co-created the Coalition to Improve Healthcare Staffing, CTIHS, and Advocacy for Nonprofit Entity. The list goes on. So that's Chris. Then last but not least is Jacob, the managing attorney of the law offices of Jacob Sapachinik. He's an active member of the American Immigration Lawyers Association. He's been invited to lecture on immigration law in the United States and abroad, published various articles on issues related to the field, provides immigration support to U.S. immigration clients worldwide. He's the founder of Find Jobs USA, one of the first job search sites focused on international workers. He's been quoted and featured by numerous newspapers, TV outlets, CNN, Money, ESPN, NBC News, ABC, Fox, ABBA, Journal, KPBS, to name a few. Written articles for various publications in North America. Graduated from Manchester Metropolitan University. These are the real deal, everybody. So please send your questions, and we welcome everybody who's watching. I see we have Joy watching, Joy Perez Altabano, Noreen is watching, Kristen Tan is watching from the Philippines, Anna Saldana is watching, Ken Lab, I hope I've got that right, is watching from the UAE, Agna is watching from Abu Dhabi, Kimberly is watching, Cabela is watching, Bell Bay, sorry, is watching. So welcome everybody. Let's get started on the questions. Before we get to the questions, I wanted to just ask the panel about the visa bulletin. We had some very exciting news this week. I know everybody was really happy. I think, you know, Chris and I were just talking before the call and talking about how this is probably the best time that we've had in many years to have a nurse petition coming to the US, and the visa bulletin is very exciting right now. Who would like to give us the comments on the visa bulletin?
You know, coincidentally, here I am in Austin, and last night I had dinner with Charlie Oppenheim, who writes the visa bulletin. So we were talking about this. And so the visa bulletin, 3 or 4 years ago, the Philippine nurses, which are in the employment-based third category, which we call the EB3 category, it had gone over 7 years. So literally hospitals and healthcare employers had almost stopped applying for nurses because there's no really good temporary visa for nurses except the ones who are in Canada and Mexico. So most Filipino nurses would have had to wait 7 years, and no employer was going to wait that long. As our previous talks about this, it had gone down to 11 months and then under a year, and it just didn't seem like it could keep going lower. But Charlie announced that in June, on June 1st, a couple weeks from now, it will be down to 7 months. And when I talked to Charlie at dinner last night, he does not see any reason why it won't even go down lower than that in the coming months. So that's, you know, a lot of other categories that we talked about are getting higher. You know, for investors in India and stuff, it's going to be a mess come this summer. But for nurses, you're in a great category. This is the ideal time to get petitioned to come to the United States.
Yeah. And I don't know, Chris and Jacob, if you want to add anything to Carl's comments, but it really is a very exciting time.
Yeah, I mean, I agree. This is, you know, people are almost, you know, they don't believe it's true when you tell them that because they hear rumors that it took so long for years, and now it's happening. So I think everybody should be informed. That's why we're doing these lives, just to get the information out there.
Yeah. Exactly.
Yeah, the only thing I mean, certainly everything Carl and Jacob said is right. I mean, the good news, just in real practical terms, is, you know, if you were to file a green card case today and you were a Philippine EB3 nurse, you know, you could realistically expect to be in the United States in under a year, which is basically unprecedented in my career, or at least since maybe the early 2000s. So, Yeah, that's just it's incredible. So as Tanya said, if you were thinking of coming to the U.S., now is the time.
Now's the time. If you need to pass the NCLEX, work on it now. If you need to pass the IELTS, work on it now. Please do not wait. There is urgency. Obviously, there is a lot of talk in the news about immigration as well. There's nothing concrete that, obviously whatever changes or regulations might come about, it's still very early days in that regard. We'll keep you posted of any new developments as they come about. But right now there's pretty much never been a better time. So let's get right to the questions. I want to carry on welcoming everybody. Jeffrey Naz, I know Jeffrey from Dubai. Dexalyn, hi. June, welcome. Chris Dendon, Ricky, good morning. Begit from Singapore. Susan, welcome. Gwen, welcome. Kashit, Jace. Victoria, I know Victoria as well. Kathy, May, Jessica, Chris, my goodness, the list goes on and on and on. So please share this with your friends, share this Facebook Live session with your friends and your family. We want to get the message out. We want everybody to get correct, accurate information about immigration. Right. So, panel, are you ready? Okay. So these are questions that Louise has posted. Some of them are confidential, and we understand that some of you want to be confidential. So some of you have sent me questions directly, and then a few of you have posted questions. Feel free to post your questions into the chat box as well if you have any specific questions that you would like the panel to answer, and we'll try and get through as many as possible for you so that you can get the answers that you deserve, and we can make your American dream a reality. And again, shout out to Louise, shout out to Jean, Paul, all the admin team of the Fora. Thank you for giving us this opportunity to help so many people. Okay, so the first question is a confidential one. The question is, this is my case. Me and my family are living in Canada. We already have a U.S. immigration permanent resident visa issued last April. The expiration date will be September 2019. So that's just around the corner. My problem is there's no available care manager in the facility. No one can do the interview. Plus, I'm waiting for my NCLEX eligibility aside from that. I still have a child whose visa is on process. My question is, can we enter the US soil to register our permanent residency, get Social Security before our visa expires, then go back to Canada while waiting for my employment? It's a little bit confusing, this question. Carl, do you want to take this one?
You know what? The waiter came up and talked to me, so I missed part of it.
Okay. So there you go, everybody. You know this is really live.
So, Tanya, I think I got the gist of it. And I guess I would start by saying your case definitely has some complex facts. So email the attorney who worked on your case. If you'd like, you can email me, and maybe I can point you in the right direction. But from what I could gather, it sounds like it might be a family-based sponsorship that the writer has, because they implied that they don't have the NCLEX passed yet. And if they don't have the NCLEX passed, they couldn't have filed an employment-based case. That's sort of my first thing. Second, they can come in and enter the United States to activate the visa before. I couldn't catch if it was a June or October date. September date. Okay. So they can do that. And there may have been another factor too that I just sort of missed, or was a little confusing in the question.
Yeah, it is a little confusing, but I think you're right, because the fact that this nurse doesn't have NCLEX yet would indicate that it's a family based.
And I think we talked about it last time, Tanya. There was a similar question last time, and basically they have their approval, and they're wondering if they can enter, and we said that they can.
Yeah.
Get their activate the visa and then go back.
Yeah. So please make sure whoever has posted this confidential question that you reach out to your attorney as soon as possible, because September is around the corner.
Right.
I can't believe we're almost at June. Okay, C. Esteban asked, would appreciate your guidance on my predicament. I have signed a contract with an employer. I passed the interview on August 2018 and submitted all of my requirements in October 2018. I have asked for a step-by-step process and timeline multiple times, but the law firm is not very responsive, and I'm sure it's not any of your law firms. It's almost 7 months now, but the I-140 is still not filed, nor can they give a timeline when it will be filed. Is this normal? If I withdraw my application, will I be charged with the amount stipulated in the contract, even if they haven't filed my I-140 yet?
Well, we'd have to see the contract, but it doesn't sound like, somebody's not doing their job. I mean, it doesn't take more than a few weeks to file an I-140. It doesn't take 7 months. So she probably wants to show her contract to another lawyer, and maybe it's time to switch lawyers.
And also, it seems to me there could be an issue between the employer and the employee. Sometimes, we've seen cases where they would just they'll drag it, and the employee is not understanding what's going on, and the employer and the lawyer are communicating, and so it could be something beyond immigration in this case. That's what it looks like to me.
Yes, I think you're 100% right. I think the one thing that I would always encourage everybody who's watching to bear in mind that there's always 2 pieces to these kinds of cases. There's the immigration piece, and then there's the employment contract piece. Because, when you talk about getting out of the contract, that is on the employment side. Am I right, panel? I mean, it's between them and the employer that they've signed with. On the immigration side, 7 months sounds like a long time. Although, I'm just thinking maybe that particular employer didn't have prevailing wage and posting done. So, that's a possibility. And I think, as Carl said, please speak to your employer and so that you can address the situation. Okay, we have another question. This is a confidential one. I have questions both for the Kinetics live chat. Would they be able to sponsor EB2 petition for adjustment of status cases in the USA? There's a second part to the question. I think we've had this question a few times, but I want us to still cover it. Would it be possible to go for H1 application after being denied for an EB2 application and adjustment of status? Chris.
Yeah, so I guess the first thing is if you're Filipino, there's not much of an advantage to do EB2. So why are you or why are your lawyers suggesting to make this more complex than it needs to be? As a general rule of thumb, and this is a blanket statement, general rule of thumb, there's exceptions all the time, but as a general rule of thumb, nurses are not eligible for H-1Bs and they're not eligible for EB2s. There's some exceptions for advanced practice nurses, nurse practitioners, some other specialized nursing fields. But frankly, if you're a Filipino nurse, it's in November, the EB3 is November of 2018. It's not current like EB2, but it's a surefire way to get your case approved. Why go through the hassle and headache of trying to make what is probably going to be an unsuccessful EB2 argument? And for that matter, even if you're a physical therapist, I don't think we have too many of those who listen into the forum is usually restricted to nurses, but same thing. We've gotten the EB2s approved for physical therapists in the past, but right now there'd be no point to even go down that path unless, so I'd go EB2 or go EB3.
Yeah. As we said earlier in the live, on this Facebook Live, there's no better time to do an EB3 green card in many, many years. So to get complicated, nurses are Schedule A, which means they're occupations of short supply, and really just go straight to EB3.
And I think the reason people are bringing up EB2s right now and all these other alternatives because they're still not aware that the EB3 is so fast. And so they're still kind of in that state of mind that it's going to take forever.
Yeah. And I find often when that happens, it's not usually an attorney that specializes in nurses, like all of you do. Because, immigration lawyers, it's kind of a big umbrella. There are a lot of lawyers that specialize in lots of different kinds of immigration law. But to focus specifically in nurses is kind of a niche area. Okay, we have our next question is from Alfred Batik. He asks, I am a UK RN currently working in England. I decided to pursue British citizenship first as a backup plan before relocating in case I don't like it in the USA. My priority date is current. The fee bill has been paid. I'm at the DS-260 stage. My petitioner is a nursing home and is affiliated to an agency private recruitment company for overseas talent acquisition. This agency has other clients, including my nursing home petitioner, to process EB3 direct hires. The agency asked for my civil documents, but I withheld them due to my above-mentioned plans. I sent the agency an email about my desire to stay in England for another 3 to 4 years, but it did not reply. Is the amount paid for the fee bill expires? If so, how long will it be valid? So there are 3 questions here. Jacob, if you want to take the first one. Does the payment expire, or how long is it valid for?
So when did she make the payment?
Female has been paid. It doesn't say exactly. I think it's pretty recent.
Yeah, so she should be good at least for a year or so. But I think her biggest issue here is whether she's going to pursue this case or not. Staying in England for 3-4 years, it sounds like she's not going to go through the actual get the visa to come to the US, right? Is that what you're saying?
Yeah. So the second question that Alfred asked is, in the future, will my decision to delay my American dream have a negative effect with my immigration to the USA if I decide to pursue relocating in a few years ahead? So I think he's asking there, if he kind of puts a pin on it, will this original case affect him relocating in the future years?
I don't think so. I mean, as long as everything is done properly and for the right reasons, you shouldn't have any issues to do it again in the future.
Okay. And then the third part of Alfred's question is, what if I decide to change petitioners? So instead of working at a nursing home, my original petitioner, what if I want to get a job in an acute care hospital? So I think he's looking at what as another contingency about transferring from one petitioner to another. And how can it be done if so?
Right. So I think it really depends on if the same terms will apply, because it looks like to me that he'll have to, and he's now at the final stages already, right?
Yeah, well, he's at DS-260.
Yeah, so I think, I mean, really the final stages, I would just probably finish the process and get his green card instead of trying to do this, go back and do it again.
Yeah. Okay, Alfred, so you heard the advice of the lawyer from the panel. Moving on to the next question. So this is also a confidential one. This is not a confidential. This is from Ching Laxon. Is it possible to transfer US Embassy location of interview from London to Canada if the principal applicant works in London under working visa and the husband is a permanent resident in Canada? I have a tourist visa to go to Canada and our child is a Canadian citizen. Okay, so there are a few questions in there from Ching. But I think the main question is it possible to transfer the interview from London to Canada if the principal applicant is working in London and the rest of the family's in Canada? Carl.
Well, I mean, we usually schedule the interview where the principal applicant is, but it's really up to the embassy or consulate of the country. If they have family members in another country and that country is willing to accept the application, then they can have the interview in Canada. Okay.
So there is flexibility, Ching. the one thing that we get also questions from a lot of nurses, I mean, I know the answer, but I just would like to put it out to the panel. Is it important that the whole family go with to the embassy interview? Chris?
I think is it possible to split the family up? Yes, but it's not advisable. We find that when the family gets split up, I've found it ends up taking a lot longer than anyone ever expected. And so, much like the last question about switching the embassy from Canada to England, as Carl said, you can do that. My advice usually is to just sort of go through a little more pain up front and fly to England and get your green card processing done. I realize it's more inconvenient, it may be more costly, but I think you'll find in the long run that it'll probably end up being more costly and more timely to break up the family. So that would be my advice. But again, you can do it. It's just not advisable.
So it's possible, but probably not advisable. And I think also it often just creates another level of stress and anxiety to get the process through. For everybody watching, it's such a difficult process. You want to try and make it as smooth and as easy as possible for yourselves. Just to share, I was on the East Coast recently. We welcomed a whole batch of nurses at one of our clients, and everybody was sitting around telling their stories about the immigration process and how long it's taken and the things that went wrong and what happened, and each one was kind of like almost trying to outdo the next. It was like, well, my story was worse. Well, my story was worse. So it really is so stressful. So I think where you can, try and keep it simple and hopefully it'll be as smooth as possible. Okay, so I'm going to take some questions from the chat. Hold on one second. Oh my goodness, we've got a lot of questions. I don't know where to start. Okay, so JM asked, hi, I am JM watching from Saudi Arabia. Welcome, JM. I just wanted to ask, what happens when your priority date is now current and you start submitting documents in the NBC and filling up the DS-260, then out of the blue in the next visa bulletin, it retrogresses? Is there a high chance that your case will be affected? I think we already covered that question, Jay, but Jacob, do you want to fill it, JM, on what we were talking about earlier?
Can you repeat the last part of the question?
Asking what happens if you get to the DS-260 and then there's a retrogression?
Well, I mean, it's basically they won't issue the visa until it's going to come back.
Yeah.
So it is.
They won't issue the visa, but I think, as we said earlier in this Facebook Live session, there's no better time. So, try not to think about what could happen. Just jump in and let's.
Exactly. Because, we don't anticipate it's going to go anytime soon, but instead of worrying, it's better to file.
Yeah, correct. Okay. Okay, let me see here. I've got the listed questions. Okay, so Kathy Mace has a question. Please give me insight. I'm already current under EB3 and I'm married. I want to include my husband. Unfortunately, he had a previous criminal case arrest. Do you think it will affect my visa approval? Should I include him in my visa interview under EB3 or should I petition him under spouse visa?
Well, she should definitely include him under the EB3, but when, just knowing that there was an arrest, we don't know whether an arrest doesn't really affect much. It's whether you have a criminal conviction. So she's got to show the arrest and dismissal or conviction records to an attorney. But since she's the principal, I want to point out that she will get the visa no matter whether her husband's eligible or ineligible for the visa. If she waited until she got the visa and then she petitioned him, he would be the spouse of a permanent resident, which is the 2A category, and the backlog is a couple of years for that. So that wouldn't be a good strategy because she'd be separated from her husband for 2 years. So they should definitely apply together. But I would say before they apply, they should show the criminal record to an attorney to see how that would affect the husband's visa.
Okay. All right. Thank you, Carl. We have a question from Chris May. Hello, I have a confusion. I already have one application denied, and my second one got an RFE last December. Then on April, this update in the application came. Yeah, so this is a question we've seen from some nurses. Notice explaining USCIS actions was mailed on April 18th, 2019. We began reviewing your Form I-140 immigrant petition for alien worker, receipt number, etc. We mailed you a notice informing you of the action we intend to take on your case. So the question from Chris May is, what does this mean? Because I'm not getting any update from my employer.
That means the decision was issued on the case, and so you should check with the employer or the attorney to let you know whether or not the case was approved or denied. It sounds like that was the case from the update. Generally, that sounds like a denial to me, but I never over-rely on the online system. We find there's at least enough confusion sometimes out of that while it does give you an indication as to which way the USCIS has acted, sometimes it's not entirely accurate. So, I mean, I think this is something where you really want to push in on the employer to see what's the status with the case.
Yeah, it does. Yeah, as Chris says, in our experience, it often is a denial, but please check with your employer and make sure that you get the answers that you need. Lester Barber has a question. Hi, I have just recently passed my exams. I'm currently under a student visa. What are my chances of changing it into a green card? Jacob.
So again, looking into the timeline right now with having more options to get this done, let's say within a year, this person needs to maintain his status as long as needed for the process to go through. So it is possible because as a student he can continue taking classes or if he has an OPT, but it is possible if he gets the petition filed on time and let's say within a year or so, he should be able to do this in the US.
Okay. I can't believe it. We are out of time already.
Yeah.
Oh, I don't know what happened to Chris.
I'm right here.
He's here.
Are you there?
Sure.
He's here.
Oh, I think something happened to your camera.
No, I see him.
I see Chris.
You see Chris? I don't see him.
I see you.
Oh, okay. I don't know what happened there. Okay, so this is the last question that we're going to be able to take today. This one comes from Teresa Cabrera. She asks, how may I ask, I'm on my process on the DS-260, however, my son aged out. Okay, we get this question a lot, but I'm going to go ahead and ask it. My son aged out and his name appeared to status as follow to join and a company in the NVC system. Now my agency lawyer noted they requested to fix the glitch. Question, I decided not to include my son in the filing. How can my son's name be fixed in the NVC system so that I will not intend to include him in the filing so that my DS-260 documents will move? What should be the action of the lawyer? I thank you for your response. Who was there? I'm trying to rotate each person getting a chance to ask a question. Who is next?
I think it's Carl. Oh.
Yeah, I'm not quite sure what the question is, but I think she keeps saying he's aged out. Hopefully, her lawyer's done the calculation under the Child Status Protection Act. So as long as her I-140, which is the petition that the employer filed for her, when the priority date, when she became first in line to get the green card, you take the son's age and you subtract the amount of time that I-140 petition had been pending. And if that makes the son under 21, then he has not aged out. If it makes him over 21, then he's not going to be included in the interview. And, he should look for another way to immigrate to the United States, because if you're from the Philippines and you apply for a you're a permanent resident, you apply for a son who's over 21, that will take years and years and years for him to immigrate. So if he's a nurse or an accountant or some kind of professional, it will be much faster than going through the family categories.
Okay. So there you go, Teresa. You have your answer to your question. We are out of time, panel. Thank you so much, everybody, for joining us on this Friday morning. We will be back next month. The panel have agreed to be doing a session like this every month. And we also have some exciting news to share. Kinetics will be hosting a series of Facebook Live sessions starting in June. There will also be once a month, and it will be called Living Your American Dream. So we're going to be bringing in experts on other topics. So right now, as we know, we brought in experts on the immigration side and on the IELTS side with Swoosh English. But we are also going to be bringing in other experts in other topics, such as how to file your taxes in the US. We're going to be talking about credit history. We're going to be talking about car loans in the US. We're going to be talking about the application process for the NCLEX, the NCLEX itself. So lots more to come. Watch out in the LaFora forum for announcements for the next series of Facebook Live sessions. But we will continue next month with the panel of immigration lawyers. And we thank everybody for joining us today, for sending your questions, and we will try and get as many of your questions answered going forward. Thank you, everybody.
Thank you.
Have a beautiful weekend. Thanks, guys.
Jacob, have a good weekend.
You too. Bye-bye.
Okay, bye-bye.
Bye.